Senator Xenophon.
Thank you, Mr President. My question is to Senator Bob Carr, representing the Minister for Defence in the Senate. Under the United States Signals Intelligence Directive 18, interception refers not to the fact of all phone calls, emails and electronic data being collected and stored, but to a human listening to or reading the phone calls, emails and electronic data content. My question is, what is the equivalent directive or legislation in Australia, and how is interception defined?
The Minister representing the Minister for Defence, Senator Carr.
Mr President, all communication interception activities carried out by government agencies are conducted in strict accordance with Australian law. In Australia, the privacy of communications is protected by the Telecommunications, Interception and Access Act 1979, the Interception Act. For the purposes of the Act, interception of a communication passing over a telecommunication system consists of listening to or recording by any means such a communication in its passage over that system without the knowledge of the person making the communication. The Interception Act prohibits the listening to, the copying or the recording of a communication as it passes over an Australian telecommunications system. Agencies such as the police must obtain an independently issued warrant for the investigation of serious offences. ASIO has to obtain the authorisation of the Attorney-General for its warrants on matters pertaining to national security. There are limited circumstances in which information can be lawfully obtained through covert means, such as murder, organised crime and drug trafficking, as well as protecting our national security. Access to these powers is governed by significant accountability and oversight by the Ombudsman and the Inspector-General of Intelligence and Security. Commonwealth agencies are required to maintain records relating to interceptions and the use, dissemination and destruction of intercepted information. So this is the framework that governs any interception in the Australian context. This is the legal architecture. These records, I should add, Mr President, must be inspected, I emphasise that, by the Commonwealth Ombudsman or the Inspector-General of Intelligence and Security on a regular basis.
Senator Xenophon.
Thank you. Supplementary. I think the Minister's been confused talking about the Act he refers to is not the same as the Defence Signals Directorate. And my supplementary question relates to metadata. Are any email addresses exempt from the Mainway, Marina, Nuclean or prison programs? For example, are the official or unofficial email addresses of Members of Parliament exempt? What about internet metadata or content from parliamentary logons?
The Minister.
Mr President, as a matter of principle and long-standing practice, the government does not comment on intelligence matters. I do reiterate, however, that we have a strong legal framework to protect Australians. Intelligence Services Act agencies, such as the Defence Signals Directorate, to which the Senator refers, are required by law to obtain specific authorisation either from the Minister for Defence or the Minister for Foreign Affairs to produce intelligence on Australia. For matters relating to threats to security, the Attorney-General must also support the approval. All such activities are independently examined by the Inspector-General of Intelligence and Security to ensure that authorisations are conducted in accordance with this law.
Senator Xenophon.
So can the Minister confirm whether metadata, under legislative powers, metadata is being obtained in relation to Members of Parliament? Can he confirm that? Because the Minister hasn't directly answered that question.
The Minister.
Mr President, I did answer the question, and I wouldn't choose words beyond those I've shared with the House, with the Senate.